Hello, and thank you for visiting Johnson & Boon Solicitors. My name is Rob Boon, and I am a partner in the law firm Johnson & Boon. We are authorised and regulated by the Solicitors Regulation Authority. At Johnson & Boon, we offer a comprehensive range of legal services that caters for both businesses and individuals alike. The purpose of this session is for me to explain a little more to you about the services that we offer in respect of tenancy deposit claims. It has been the case now for a considerable period of time that if a landlord receives a deposit from a tenant who occupies the property under the terms of an assured short-hold tenancy, then that deposit must be protected within one of three government-backed schemes. It must be protected within 30 days, and the tenant must also receive a scheme leaflet and some prescribed information. If this very specific process is not followed, then the tenant has a claim against the landlord by way of a statutory penalty. So how do you know whether your deposit is protected? Well, the likelihood is, if you don't know where your deposit is, you've never received a scheme leaflet, nor have you received any prescribed information, then the deposit isn't protected. However, at Johnson & Boon, we can very easily conduct searches of the three tenancy deposit schemes to establish whether your deposit is or isn't protected. So if your deposit isn't protected, what sort of value would your claim have? Well, the Housing Act 2004 sets out that a court must award not less than 1 times the deposit and not more than 3 times the deposit for each separate and distinct breach of the legislation. In addition, you can also claim back the value of the deposit if this hasn't already been returned to you. There are other factors to take into consideration. For example, it may be that you initially occupied the property for a fixed term of, say, 12 months. If at the end of 12 months you remained in the property, you will have either signed a fresh AST or you will have remained in the property under the terms of a statutory periodic tenancy. Either way, unless the landlord at that stage protected the deposit in the correct manner, there is a whole fresh set of breaches to be taken into consideration, which considerably raises the value of the claim. It is also important that I note that even if you've had your deposit back, and even if you have now left the property, you can still make a claim, provided that you occupied the property at some point since 2012. At Johnson & Boon, we have an in-depth knowledge of this legislation. We understand the key points of all of the case law which has led us to the position that we are in today, and we know procedurally how to deal with the case so as it is dealt with quickly and with the best result for you. So if you are unsure as to whether your tenancy deposit is protected, or indeed if you know it wasn't, telephone my office on 0151 637 2034 for a free, no obligation discussion about your case. We do act on a no-win, no-fee in respect of these matters, so we will never ask you to fund what can be costly litigation. Thank you for listening to me today, and please do take some time to explore our website at www.johnsonandboon.co.uk for an overview of the other services that we offer.